right, Lindsay? I think it's 11 o'clock, so I'm going to get the group started if that's okay with you.
Go ahead.
Great. Hi, everybody. This is Lara Hoff from Humber College, more specifically for this great occasion, representing the community of practice of student conduct. And on behalf of the community of practice, we're really excited today to welcome back Dan, who frequents us because every time we seem to bring him in, everybody seems to want to ask him so many extra questions. So this was a great opportunity that we were able to connect with Dan and ask him to come in and do a presentation for us on examining evidence and determining credibility, really after we started a great conversation at Seneca College on the topic of sexual violence training, and Dan was able to help shed some light on how we should be managing that complex matter. So without further ado, I want to just share with you a little bit about Dan and then share a little bit of housekeeping and then turn the table over to Dan for us to get started. So Dan Michaluk is a partner at Hicks Morley. He has an active practice in post-secondary education sector. He frequently joins us and helps advise Ontario colleges and universities related issues. And essentially, he has been super helpful in helping us kind of navigate some of these more complex matters in post-secondary. So in a moment, we will welcome Dan. If I could trouble everybody, a few housekeeping items. It is important if you could please mute your line. On our end, we have muted you as well, but if you could go ahead and please mute your line and be cognizant of that. There is always an opportunity to ask questions, and you can do so in the chat box that's in the bottom left-hand corner of your screen. By all means, please feel free to type in a message, and Dan and I will be monitoring your questions, and we'll field them as the presentation moves on. The conversation today and the presentation is being recorded by Caucus, and the information will be available on the website at a later time. It is also going to be available on the YouTube channel that Caucus hosts in about 5 to 7 days, so that's an opportunity for folks to revisit the content. One additional note is that if you do experience any technical difficulties during the presentation, it is best to email membership@caucus.ca, and the lovely Lindsay will be able to help you out and just navigate your technical difficulties with you. So that being said, Dan, if you're ready, we would love to hear more great wisdom from you on how to navigate these complex matters.
Thanks, Laura, and thanks, Lindsay, and nice to be here. And I can see the list, and I see a lot of familiar names on it, which is great to see. Hello to everybody, and welcome. The topic today is, as you see on this slide, student conduct investigations, examining evidence and determining credibility. And as Laura said, this is not about sexual violence today, but we know that sexual violence has led you into some more challenging investigations. Investigations where there's no direct evidence about what's happened except what two people say. And the association wanted to give you some support with these types of issues. The idea is to put you at ease with these types of investigations and to give you some ideas to work with and apply. I've tried to do that with this slide presentation, you'll see. And ultimately make you more likely to reach the right answer, which is the ultimate objective. It's an objective that's good for survivors. It's a good objective for respondents, and it's a good objective for the institutions as well. So that's what we're aiming for today, and we'll do it in these 4 parts. I'm going to start with the investigator's role, and then once we're beyond that, that will set the context. We're going to drill into a process, really. The process of investigation, in one sense, involves 3 parts: collecting evidence, analyzing the evidence, and recording your analysis. And we're going to work through that. The focus will be on the 3rd bullet, the credibility analysis part, and we'll deal with that subject in some detail. So that's our plan for today. Let's start with the investigator's role, so you have a frame of reference. And the primary role is quite simple. It's to figure out what happened. You see that in the 1st bullet. I've underlined the word likely, which is important to us. It's a reference to the balance of probabilities, which is a concept that we're all familiar with. You know, he said this happened, she says that happened. what is more likely to have happened. Okay, and that's the investigator's role, is to determine the likelihood of one thing being true versus another. That is a duty and a burden that you all wear as investigators. You may get a little bit anxious about that, particularly when the investigation is hard. But to put you somewhat at ease, you're not making a definitive finding. You don't have to say what happened for sure. You're saying, I've applied the logic and good analysis, and I've reached a determination about what is most likely to happen, and that may make you feel a little more comfortable with the role. If you were on a presentation that I did for this group probably about a year ago now, you'll remember a University of Waterloo Human Rights Tribunal case in which the tribunal reached the opposite conclusion in a harassment case than the university reached, and did not at all punish the university for that. Again, that illustrates that we're dealing with likelihoods and probabilities, and that it's okay to get it wrong as long as you do your best. Okay, so that's a little bit of something to put you at ease as you start. That's the first bullet. Then the remainder of the bullets on this slide really go through the process that we're going to be talking about today. You're thoroughly gathering evidence. That's step one. It can be testimonial or oral evidence from interviewing witnesses, and we'll talk about techniques for doing that. And it can be documentary and other real evidence, okay, evidence that you can touch and feel and look at. And you want to gather both sources, and you want to be thorough. That's step one. Step two is the core of our presentation today. You're analyzing evidence, okay, and you're looking to see whether one theory is more probable than the other, and how the evidence weighs in favor of one theory versus the other. And you're looking to see how reliable evidence is. That's the core of the analytical task, okay? What does this mean, and how reliable is it? And then the third step, and we're not going to spend too much time on this today, although it's a subject of its own, is recording your analysis so it can be understood by decision makers and by the parties. We know that it's long been a duty to record your reasons and convey them to the people who you investigate. We now in Ontario, as of just earlier this week, have a statutory duty to provide a form of reasons. I think there's some debate about what exactly that means. So that's your role. Let's talk briefly about the relevance of the rules of evidence. Okay. So I'm just collecting my notes here. You are not bound by the rules of evidence, but the rules of evidence exist and are relevant to your work. To give you one example, we all know the concept of hearsay evidence when one witness tells you something that another witness saw or observed. Okay? And as investigators, you're not precluded from receiving that type of evidence. In fact, it's important that you gather it. It's the only way you'll know to follow up with the evidence with the witness with firsthand knowledge. Okay? You can also carefully rely on it. Okay? That's one rule of evidence. I'm going to talk about character evidence and similar fact evidence today as well. And I'm going to talk about the principles of evidence. All of those rules don't strictly apply. The reason, though, I'm going to talk about those principles is they inform the logic of your exercise. Okay, so don't be misled by my discussion of evidence, principles, and rules today. I'm not suggesting to you that you can never, incorporate evidence into your analysis that wouldn't be admissible in a court. But it is more to get you thinking logically about the evidence that you gather and assessing it appropriately. That's the role of the rules of evidence. Let's move into the first of our three parts of the process, collecting the evidence. And the highest prescription to you that I'm going to give is, in order to conduct a good credibility analysis, you need to be very thorough in what you gather. And here's an example to illustrate that. We've got a survivor and a respondent with conflicting stories. It's a she said, he said, a classic case. If it looks like this on this slide, it's quite a terrifying thing to look at when you're an investigator charged with making a decision. How the heck do I know what happened? But a good investigator goes from this into an in-depth analysis based on evidence that's gathered. Okay? And here's some tips in general on collecting evidence before we complete the analysis. Use who, what, where, when, why, how. Okay? All of those questions, and apply it to your scenario and keep asking. Okay? That's one tip. Another tip is to envision a scene in your head that you're setting. And don't stop until the scene is complete. And complete the scene with input from your witnesses and documents and other evidence, and not with assumptions. Okay? Too often I see as counsel investigations that come up where there are a lot of gaps filled in by assumptions, and you've got to push by those assumptions and actually gather the evidence. That's key. So let's see what happens with this one when we drill into it. Okay? So we gather some evidence, and we learned that the incident happened in a park. Okay? I would label this contextual evidence, to put a name on it, and it's relevant, and it tends to prove the survivor's story. Okay? And we have to know a little bit about the respondent's theory to complete the analysis. The respondent's theory, let's assume, is that this interaction with the survivor is consensual sexual activity. It's a fetish. We did this in a park. And one asks, when looking at this fact, well, what kind of consensual sexual activity actually happens in a park? Okay, so it tends to prove the survivor's story. Okay. Here's another piece of evidence. He choked two others in identical circumstances. This is an example of similar fact evidence. There's a name for it. And when evidence about other actions is strikingly similar, and that's a legal term or a legal test, it can prove the propensity of someone to take action. Okay? And it has to be strikingly similar. If it does, the evidence goes beyond character evidence and tends to prove propensity. Okay? So here we have another fact which tends to support the survivor's story or theory. Here's a third fact, okay, or a piece of evidence. They had a reason to be fighting. Okay? We're going to talk about motive today, and this is evidence of motive. Okay? And evidence of motive can be very important in deciding a credibility dispute. If they had a reason to be fighting, it is more likely that the survivor's story is true. And finally, we may find in the course of our investigation corroborating evidence. Okay, so evidence that is independent of other evidence and tends to support the same conclusion. That's corroborating evidence. Frankly, this takes it well beyond a he said, she said case at this point, and we have a rather significant fact weighing in favor of the survivor's story. Right? So that exercise is really to illustrate 2 points. One, it really is never a true he said, she said case. Okay? I want you to take that away from you. Okay? It's very easy to start as a he said, she said case, but a good investigator, which you all are, will find the other facts and base the analysis on other facts. It's never a true he said, she said case. There will always be other evidence at your disposal. I I have another point here. I think it's the same point. You have to collect that evidence to do your credibility analysis. And so that's the first learning that I want you to take away from this session, is there's always other evidence to be gathered that informs the analysis. Okay. This is really a summary slide. The part I want to focus on is bullet 2. You should apply the concept of a case theory, or the theory. We lawyers talk about the theory of one's case. It will help you in your credibility analysis. And I'll use the example we just went through to illustrate. So we don't think of the respondent's story case simply as she consented. Okay, we need to put a theory to it. Okay, and a theory of a case is something that explains why the facts support a conclusion. Okay, so a theory, if I could articulate it for the respondent's case here, is this was part of a fetish that we engaged in. Okay, so that's how I would state the theory, which is a far more useful thing to work with than simply she consented. It speaks to how to understand all the facts that you gather. It also begs questions. So once you define the theory as it was a part of a fetish that we engaged in, you can immediately generate questions. Well, had you done this before? How often? Always in a park? And you go from there. So the point is, think about the theory, define the theory, write it down, and then you'll have a basis for investigation that's much stronger than you otherwise would. Okay? And there's lots of readings on the internet if you Google case theory, and that's a worthwhile examination for you to go into, in my view. Okay? Let me just address the last bullet, which is a point that comes up in a lot of the recent discussion about sexual violence. It is absolutely the case that sexual assault complaints, sexual violence complaints, can be upheld without corroborating evidence. Okay? The lack of corroborating evidence does not mean that the survivor is lying. Okay? And that's an idea that I think we all understand well and need to work on, because we may have our biases. But that is not to suggest the opposite. And this is very important. You must still look for corroborating evidence. In fact, that may be the most important task that you have, is to look for corroborating evidence. Okay, and I just wanted to make the point that one does not equal the other. So we're moving on in our discussion of collecting the evidence, and let's deal with tips for getting better testimonial evidence. I've used lawyerly words there, but I could have said tips for conducting better witness interviews. And here are some. The first 3 bullets are really about the structure of an interview. And if you've done interviews for a while, you probably have a good sense of the structure and the reasons for the structure. The objective, and sometimes the hardest thing to do, is to get a witness talking to you, okay? Because they're nervous, particularly if they're the subject of examination or investigation. So you want to put them at ease. You want to tell them you're neutral, tell them that your objective is to be fair, and tell them that you have not made any conclusions, and put them at ease. You can demonstrate it with your body language. You can demonstrate it with your words. You can demonstrate it even by the setup of the room. And again, there's lots of literature on this to get into, but the basic point is your first objective in setting up an interview is to put the witness at ease and make the witness comfortable in talking to you. And then, of course, they're structuring the questions, and we start generally with open-ended and easier questions. That puts the witness at ease some more. And you're going to save your probing for later. You can save it for later in a single investigation if the witness is an easy witness. If the witness is a tough witness, sometimes we save the probing for even a second interview. And that's a judgment call that you'll get very comfortable in making over time. Okay? And again, I always go back to keep asking, don't rest on assumptions. Lawyers who do these types of cases, we get investigation notes all the time, and I tell you, the biggest thing that I tend to see is investigation notes that are very cursory and that don't probe into all the details. They don't ask all the who, what, where, when, and why, and sometimes it doesn't matter, but sometimes it leaves you hanging. And so I encourage you to really slow it down, to take your time, and like literally slow the pace down, okay? Because sometimes you're nervous and you want to rush. Gather all the facts. Okay, that's my encouragement to you. That will enable you to take verbatim notes. Okay, and let me stress that individual words that a witness says to you can be extremely important. He touched me on. Let's take the example of a harassment scenario where the complainant or survivor says, he touched me on my elbow. Later on in the process, perhaps in a hearing or somewhere else, the witness says, he touched my forearm. Okay. If you did not record the word elbow in your notes, you've lost that. And that's a very significant difference in testimony there that rests on a single word. Okay. So verbatim notes are important. They're hard to take. All I can say is do your best. There are ways of, sometimes you'll have a scribe. I think that's fair. Again, there's a trade-off because that tends to make the witness less forthright, which is why I say that audio recordings should generally be avoided. Some of you may use it. I'm not, there's no black and white rule. But I think the thinking is audio recordings will tend to shut a witness down and should be avoided for that reason in some cases. Okay. And then there's the process once you're done the interview of making factual notes about demeanor right away. Again, demeanor we're going to get into may be relevant to credibility analysis. I think and it's important to record your notes about demeanor because you'll forget that. What I and other lawyers don't need to see or want to see is what you were thinking. Okay, I thought this or I thought that. If you need to record that for your own purpose, I suggest you record it in a separate note. Okay, and that note may not need to be retained like the witness notes. What should be in the interview notes is factual observations, factual information about what you saw, what you heard, and that's it. Okay, notes about thinking are always problematic because thoughts change over time. Use of documents in an investigation. I could be more precise with this first bullet and say use of documents in an interview. Okay, so documents and other evidence, real evidence, will make your investigation easier. I think you probably all understand that those are collected in ideal circumstances before you interview anybody. Okay, if you do that and gather your real evidence first, you'll be better prepared and you'll save time. You won't have to go back to witnesses to say, now that we've got this document, take a look at this. You don't have to give the documents to witnesses in advance. I'm not saying that may not be appropriate sometimes if the witness is a friendly witness or if you're rushed, for example. But you most likely should not do that. Okay? And this is different. This is not an adversarial hearing where you have a duty to disclose. If that's the case, you'll disclose in advance. Most of the time, in an investigation, you'll withhold the relevant documents. You'll conduct your open-ended part of the investigation. And towards the end of the investigation, you'll then present the witness with documents for comment. Okay? And sometimes a witness will say something that, the reason you do that, let me say, is that sometimes a witness will say something that contradicts the document. And observing how a witness deals with that will really help your credibility analysis. It's a very important technique to use. Okay, and it doesn't mean the witness is lying. The witness may just not recall things, but it's useful to know that the witness, has lost that ability to independently recall things. It's also very useful to put the contradiction to the witness because you can see the witness's reaction. An honest witness will immediately see the contradiction and admit that what they said earlier was just wrong. A dishonest witness will try to reconcile inconsistencies that just can't be reconciled. Oh yeah, when I said that, I meant this. And you'll get an immediate sense of how honest they're being with you. So that's an important technique, and it rests on the use of documents and withholding of documents, which again I think is quite legitimate in an investigation in most circumstances. So gathering evidence. We've gone through the first part of your investigation, and again, my themes are collect lots of it, be very thorough, because that's what you'll need to conduct your credibility analysis. Let's move to part 2. What is credibility? What is credible testimony? It's testimony that's reliable or worthy of belief. Okay, so you're really trying to judge the reliability of what someone told you. Okay, and again, testimony can lack reliability for a number of reasons. One, it can be, there can be a benign reason. Some witnesses just don't recall. And in a sense, you're analyzing the witness's ability to recall and observe. And that's part of what you're doing. You're also, and this is maybe more obvious, is we're trying to figure out if people are purposely trying to deceive me and speak what they don't believe. That's probably the definition of a lie. Okay. The last point on this slide is very important to keep in mind. Okay, testimony can lack credibility, but that witness is not necessarily a witness that should be written off as a whole. I think that's the basic point here. And let me tell you, as someone who calls evidence from witnesses and interviews them, that I often see witnesses who have problems around certain areas. I'll be interviewing them and prepping them, and they'll be speaking very, very directly and clearly about certain matters, and then I'll go into different subject matter areas. And the classic one for me is facts that surround a decision that's obviously wrong or challenged to be wrong and probably wrong. And the witness will automatically kind of clam up and get somewhat evasive and less forthcoming, which means that in dealing with that evidence at a hearing, I just won't call evidence on that part. I'll know that they're not going to testify credibly around that, and I'll try to avoid it to the extent I can, because the witness will be perfectly comfortable with other material. Okay, so that's, witnesses are not to be disbelieved in whole because part of their testimony lacks credibility. Keep that in mind. This is not to suggest that some witnesses are to be disbelieved completely because of all of what they tell you is just problematic. It happens, but you have to be wary about writing off a witness too soon, writing off testimony from a witness too willingly. This is a statement from the most famous case on credibility analysis. If there's ever a credibility issue in a case, the decision maker will likely refer to this case or quote this passage. So I have to give it to you, even though it's a piece of law. That the essence of it is it's a warning not to rely too heavily on demeanor. Okay? As an investigator, you can interpret demeanor in your analysis. Okay? You have a license to do so. But bear in mind, we, including myself, we are not human lie detectors. Okay? We just don't have that magical ability. And it's not the essence of your analysis. That's what this case says. Okay? The essence of your analysis, the case says, is the application of sound logic. Okay? You're going to look at all the evidence. You're going to look at it, and you're going to try to kind of figure out what's consistent and what it tells you about what is more likely to be true or not. So you're going to look at logic, you're going to rest on facts and evidence, and you're not going to rest too heavily on that sense you have of someone's demeanor. Okay? That's safe credibility analysis. And it's demanded by the law. From that, we get to two principles. Okay, here's principle one. Okay. Examine how reliable the statement is in light of proven facts and clearly known facts and norms of behavior. Okay, so let me give you we've already seen an example of coherence, right? She was crying in the park. Okay, I'm going back a few slides now. That is consistent with or coherent to her story. That this was kind of a violent assault. Okay, simple. And clearly known and norms of behavior. Now this slide here demonstrates a plausibility problem. Okay, so she says we were kissing in the park, and then he choked me out of the blue. And the gentleman on the right with the tie is your investigator, and he's going, what? And he's saying what? Because people, generally speaking, don't kiss each other and then choke each other out of the blue without a reason. Okay, so there's a plausibility problem with that evidence that is, that needs to be considered in conducting a credibility analysis. In fact, the statement or the evidence is implausible absent some explanation. So if I was this investigator, or if you were this investigator, you would pursue the explanation. And if there is no explanation that makes that statement plausible, you'll have difficulties accepting the evidence. The second principle that flows from the Farnia case is about bias, and you must consciously set aside your biases. Okay, bias, to define it, is a prejudice in favor of one thing, and in a way, it's the enemy of logic. Right? So set them aside. And here's a simple example. Okay, so Johnny is in the green shirt, and he did something wrong. We don't really know what it is, but Johnny says, I didn't do it. And our investigator thinks to himself, he doesn't articulate this because that would be quite harmful. This is the third time Johnny's been before me, and he tells me he didn't do it every time. Okay, that's an application of bias. Okay, it's really looking at bad character evidence. Okay, Johnny's a bad character, therefore he had a greater propensity to do the thing we're looking at now. If you apply that bias, you are more likely to get it wrong. So you have to rule out that and other biases. Okay, so and infuse your analysis really again with logic and facts and evidence. Okay. We're concerned about sexual violence nowadays, and we talk about the rape myths, and I've just listed them here. I believe I got this list from the Ontario Women's Directorate list. These rape myths invite bias, okay? And you need to understand what they are, and you need to challenge your own application of them in investigating a sexual violence matter. Sounds easy. The tricky part, though, and this may not be well understood, is that the prescription is only not to rest your conclusions on rape mythology. Okay, and just to illustrate, crying. You see the third bullet, and we've dealt with a scenario that involved crying already. It's relevant. It's relevant evidence because it's a fact that tends to confirm one story over the other. Okay, so evidence of bruises and cuts you see here too. Again, it's relevant evidence. So your investigation will have to probe at these facts. There's no question about that. You need to gather it, but you need to analyze it, and more importantly, you need to analyze its absence extremely carefully, okay, and in a manner that's fair to the survivors. That's the prescription, and it's rather subtle, and you have to think about that carefully, okay? Because these are actually, again, the basic point is there's a lot of relevance to some of these inquiries, and you'll need to make them. Here's a list of factors. Okay, so again, coherence is an important concept. Really, you're looking for evidence that fits with itself. Oh, sorry, internally and other evidence. And by internally, I mean if a witness is telling you things, the things that the witness is telling you need to fit with themselves. Okay, and then you're going to look to see whether that witness's evidence fits with other external evidence. Okay, corroborating evidence, for example. And then you're going to look at plausibility. We talked about plausibility. So does this just make sense? Like, does this fit with, our collective understanding of how life works? Okay, and you have license to look at that. Again, you have to be careful about applying biases. Okay? And then you're going to look at things that are more subjective, motive and demeanor. Motive is very illuminating, and I want to stress that to you through this example. Okay, and let's look at an example. So here's a harassment or bullying scenario, very common in your institutions now, too common, frankly, where an employee is called up for being abusive to another employee. Okay, and he says, I think the scenario to fill in the gaps is there was a work-related problem with how this other person was doing his or her work, and a confrontation. And the defense is, I made my point to her. Yeah, it was important, but I wasn't abusive. Okay. Let's look at how the questioning may go here. Well, getting the problem was important to you, right? Yeah. And you told him to fix the problem 3 weeks ago, right? Uh-huh. And twice more. Uh-huh. He didn't fix it. He didn't fix it, you're right. And that was frustrating. Yeah, it frustrated me. Okay? So you can see how now he's admitted a motive. Frustration. Okay, and that motive makes the allegation of abuse more likely than not. Okay, and that's the simple illustration from this example. Of course, I can't present this example to you without making a point that alleging that something was abusive without factual backing is problematic. Abusive itself is a rather subjective concept. So if I was questioning the complainant, and I would have before talking to this respondent, I would have asked questions like the following questions. What words did he speak? Was he standing or sitting? Okay, how was he poised? How loud did he speak? How long was the conversation? What tone did you hear? Somewhat subjective, but I think it's a fair question. And what were you thinking when he said that? Okay, so you can see again. That's that little nugget there is more an example of thoroughness in probing, right? Because the more detailed facts you have from the complainant, the less you'll need to rely on the motive in any event. Okay, because you'll go much beyond the subjective concept of, yeah, it was abusive. I really, again, my focus or my key message is that demeanor is probably something that you shouldn't focus on. But part of the credibility analysis is getting into things that are more difficult to pin down. Okay. And I'm generously lumping what you see on this slide under the concept of demeanor. And I would keep a list of these, and use them in your analysis, right? So you're looking at an interview that you've taken, and you're applying your analysis, and you can look at this list and go, okay, well, what do I see here, right? And just use it as a little checklist, okay? And I think by using a list like this, what you'll do is it'll help turn your, well, I just didn't believe him feeling into something more concrete, something more objective, and something more defensible in the end. Okay, and that's really, again, that's the theme here, is you're trying to push beyond that feeling into something that's defensible and concrete and based in logic rather than feeling. I can't talk about demeanor without raising the point that demeanor is, can be when you're like pure demeanor, like facial expressions, tone of voice, and similar behaviors. They're generally misleading, and one of the reasons they're misleading, and I know that you're all dealing with very diverse populations, can vary with cultural norms. Okay, so again, you're not a human lie detector. And the challenge of becoming a human lie detector is made even more difficult when you're dealing with people from different cultures. Okay, so that's just a warning. That little blurb there. Character evidence is interesting. Let's look at it. And to be more precise, what we're doing here is we're illustrating the difference between character evidence, which should generally be avoided. Okay? If you're in a court of law, character evidence is not admissible. Okay? Versus similar fact evidence. And again, in a court of law, similar fact evidence is admissible. Let's look closely at this scenario. So we've got our same fellow there before. I made my point, but wasn't abusive. And the woman with the pink hair is our investigator. She's dressed for casual Friday, apparently. Dressed like I would be on a Friday. Billy was charged with fighting last term. He's a fighter. Okay? Bad logic. It's reliance on Billy's character to draw a conclusion about whether he has the propensity to do the bad thing. Okay? So that's bad analysis and should be avoided. That's reliance. That's an example of reliance on character evidence. Versus, well, we've had 3 issues of Billy doing this before that are very similar. Okay? That's similar fact evidence. Okay? And it's much more reliable. Okay? If it's strikingly similar, it's admissible in a court of law. If it's strikingly similar in your context, you can give it some weight. Okay? Is it proof positive? Is it something I would, treat as the most important evidence I have? Probably not. I think we can sense that it's got a little bit of frailty in any event, but it can and ought to be considered if it's strikingly similar. That's what logic demands. We're flying along here. We've got time for questions at the end, and I'm going to encourage questions, so I'll give you a heads up. Start thinking now, please, about your questions. We've gone through the first part of our process, which was gathering the evidence. The second part of the evidence is analyzing the evidence. We've worked on credibility analysis. And finally, you need to record it. Okay? And we record it for a number of reasons. One of them is there's a legal requirement to give reasons. And again, now in Ontario, we'll have a statutory requirement to give at least some form of reasons. Here's some points on recording your analysis. First of all, and I've said this already, there's no need for creating a permanent record of the twists and turns in your thought process. Okay? And so, I'll deal with things that I see and I would advise against. Recording thinking in investigation notes is common. Don't do it. It just poisons the notes. Okay? Thinking in email. Okay? As an investigator, you want to reach you you kind of want to get independent input from people, and I think to some degree to talk with a colleague about a difficult case you're dealing with is perfectly fine. The decision in the end is your decision to make, but don't talk about it over email and what you're thinking. I think that's frankly just deadly. Again, because your decision may change in the end, and it will 90% of the time change in the end. And that record that you're creating can only be used to undermine your decision or conclusion. So don't do that either. If you want to keep a note of your thought process, keep a note to yourself. Okay, and that's in your investigator's file. It is something that can be disposed of before before other records, frankly, and is to be kept highly confidential. And I think that's fine. It may ultimately be producible, frankly. But I think that if you're going to do that, I think that's the best way to record your thought process. Okay. In writing decisions, credibility analysis is, particularly demanding. Okay, so I believe this person, because you're concluding that someone was essentially, not giving accurate information. Okay, either because they're lying, or again, because they don't remember. So you're making a negative judgment about someone, no doubt. And you're going to, and it's a judgment that we've seen rests on complex analysis, okay, and very nuanced analysis. There is case law that suggests when you're articulating a conclusion on credibility, a decision maker has to be more detailed in their analysis, and I think that's appropriate. Generally speaking, you're going to address all the relevant evidence, including evidence that does and does not support your analysis. Okay, and there's a limit. I'm not suggesting that you write pages and pages, but you're going to have to capture the whole of your analysis in a way that does yourself justice. So strive for that. I say create a bullet list. This is a technique that I've used in recently in doing closing argument where credibility is an issue. What I do is I record all the factors, right? It's a multifactorial analysis, and I just create a bullet list. For, against. And obviously, as an advocate, I'm trying to minimize and explain away the against. But you can do a similar thing, both in your workup and in your decision making. And you'll come to a good record of your analysis. Okay. We are finished with 10 minutes for questions. And I don't see any questions here yet, but I'll invite them.
So, Dan, if we go into the chat room, there are 2 questions. So if I could actually just read them to you, Dan, and then maybe have you address them. So our good friend Mark, hi Mark, is asking, can you address the concept that a lot of us have a statement in our policies that the, quote, survivor will be believed, end quote, and how that fits with credibility tests?
Yeah, that statement comes from, I believe, the Ontario Women's Directorate materials. I think it's got to be taken with a grain of salt, right? It might have been better for them to say the survivor won't be disbelieved, which is really an admonishment not to apply the rape myths, And if you interpret it that way, which is how it should be interpreted, you'll be all right. If you interpret it literally, your investigation will be flawed in principle, right? It's obviously problematic. So interpret it that you won't disbelieve the survivor, and you won't apply the rape myths, and you'll do a proper credibility analysis, and you'll be fine. If it were up to me, I would take that out. It's not correct. So
thanks, Dan. Deb from the University of Alberta asks, what role might evidence of trauma play in a sexual assault investigation? And goes on to ask, a clarification on her question is, the norms of behavior can be radically different from trauma when trauma is a factor. First of all, my first observation is it sounds to me like I'm speaking with someone who has
better knowledge about sexual assault trauma than I do. And I suspect that 90% of the people on this call have better awareness of sexual assault trauma and how it will affect behavior than I do. That's a good thing. That's a good thing, and that's why it's important that you're investigating these things. That's an asset that you bring to the investigation. My simplistic outside counsel litigator view of it was embodied in the crying fact that we looked at in one of the scenarios. So it can be relevant. It can tend to prove or disprove things, but it is. But you have to be careful in interpreting it. And you, as experts, have a better ability to interpret it. And I think you can rely on that expertise. You need to be careful about that and be careful about the expertise that you're relying upon. Are you relying on study X or study Y, or are you relying on a theory that's way out there? But I think there's some scope for doing that. And that's why it's you that's investigating this. You're the experts. I'll tell you that if those issues came to trial, that's where sometimes you get into expert evidence because the trier of fact needs help interpreting the fact in the way that you do. But if you're confident that an expert would ultimately testify to the interpretation that you're applying, then go ahead. It's a bit of a non-answer, but an answer at the same time. I hope that's all right, Lara.
Sure. So Dan, we've got another question from Heather Lane Batir. Heather's asking, we often hear from security that someone is being, quote, evasive. So one of your slides says, beware of evasion. Can you talk a little bit more about this?
Yeah. Let me see if I can find that slide. Yeah, sorry, that was that's a good thing. That was a kind of an indication that you're watching for that. Okay, so I'm not saying don't consider evasion. I'm saying you're looking and you're going to be skeptical of a witness if the witness is evading questions. So Heather, that's a sign that your security force is applying, analysis that's sound. Again, if they're driving their conclusion based on someone's evasiveness, they've got a logic problem, right? But it's part of the analysis, right? Hopefully you have far more solid reasons to figure out one thing over another, but evasiveness is something to consider for sure.
All right, Dan, as always, you're pretty popular, so the questions are pouring in. Rob Marsh is asking, just wondering what elements of due process are required through our process.
Yeah, well, it's, there's no black and white. I don't have a checklist for you, Rob. I apologize. I'm sure I could develop one, or there might be checklists out there. Conceptually, you're conducting an investigation, not a hearing, and there's usually a hearing afterwards that tends to cure, defects in due process or limitations in due process. And we dealt with one already today, which was I'm not giving a witness documents before I talk to the witness. Again, I think that's absolutely fine in the context of an investigation. And it's not being unfair to the witness to do that. Ultimately, it's to me, fairness in an investigation process is about keeping an open mind and about giving a witness a chance to address all of the allegations against him or her, or any kind of assertions that are contrary to what his or her theory speaks to. That's a principled answer to your question. We could probably work on a checklist as well.
And so, Rob, if you're listening, this is Laura, and a resource that's coming out and we're hoping to launch at the caucus conference in June is the new revised procedural fairness monograph that was originally published by Lynn Smith back in the 90s. And so stay tuned for that. That will probably help guide a little bit of the question that you're asking about that due process, because we will have a bit of that checklist developed already, so stay tuned for that.
Awesome.
Yeah. Just a reminder for folks, the slides will be available through the caucus website, including this recording through the YouTube channel. So I'm cognizant of time, but we have a few more questions. So Dan, we're gonna still keep going here. Keith, who is from Humber, is asking, just curious, is there another way to establish a decision of, quote, he did it, other than using the balance of probabilities? So, for example, if you have overwhelming volume of believed bad behavior that shows a history, is it enough to prove guilt?
No. There really is no way to avoid the type of analysis that we talked about today. And the concept of finding someone guilty because of past acts is dangerous, for sure.
Okay. Maggie Ross, doing these things well takes a lot of time. Many of us are used to multiple hats that can include the intake, the investigation, and the decision making, all being done by kind of one person. Do you have any suggestions to make this a bit easier?
I don't know if I have suggestions. I realize that everything that I've given you tends to involve greater effort, slower investigations, more questions, and so on and so forth. And I empathize with you significantly. I think that's the best I can do, is give you my empathy and give you a vote of confidence if you're seeking greater resources, because this stuff is hard. And and frankly, there's nothing I can say that would make it easier. I think if you understand the concepts that we're dealing with here, and if you get better and better at it, you can. A very experienced investigator can be much more focused and get what they need without getting what they don't need. And when you're a less experienced investigator, you tend to take more time because you go broader, because you don't quite know what you need. So maybe that weighs in favor of hiring more experienced investigators. Maybe that's one practical thing to think about. But that costs money, and it's either time or money, and I know I'm empathetic to the constraints that you're all under.
All right, I'm going to move on to Jordan. Keith, I see your question, but I'm going to move to Jordan quickly here. Can you speak to how to acknowledge using some information from a witness, but not all, based on the credibility in reporting of your analysis? So how do you distinguish between what's credible and what's not?
Yeah, which I did say to you, and I think that's right. So you're going to analyze different components of the witness's testimony differently, right? So he asserted this, and this doesn't fit with that. And when he was saying it to me, he was evasive, and he didn't answer that question, even though it begged a clear answer. So I'm not going to accept that assertion, and I'm going to accept the other party's assertion on that. But, he said a lot of other things that fit perfectly together. And quite frankly, my other witness was saying things that made absolutely no sense. Right? So you get a picture through that little piece there that it's not as simple as throwing out one witness or the other. Okay, you actually have to look at the various assertions that are being made by the witnesses and assess them independently. And again, sometimes a witness has made so many assertions that lack credibility that you get to the point where you can't trust anything the witness says. But that's probably rare. So I hope that illuminates that piece for you.
So Dan, we've got two more questions, and maybe we can try to just address these two last questions from Matthew and back to Heather. Matthew's asking, what is the best practice to move forward when a respondent has been advised not to speak to the allegation?
Well, I mean, you're doing two things in that case. I think you still have a duty to figure out what likely happened. Okay, I don't think you necessarily accept. That's a good question. You don't necessarily accept what the complainant is saying. Okay, that would be improper. You still have to analyze what the complainant is saying and seeing if you could rely on it. But and it's going to be easier for you to do that because you don't have a conflicting story, right? So so you're gonna test the complainant's evidence and figure out if it's believable. And if it's believable and the respondent doesn't answer it, there are circumstances where sometimes the failure to answer, I think you probably need to really put that story to the respondent clearly. And if the respondent doesn't answer and doesn't have a reason to answer, you can also infer that the respondent doesn't have an answer, which helps your conclusion along. It gets complicated if the respondent is charged criminally and you're investigating anyway, which may actually be rare because they have a reason not to respond to you. So you're not allowed to conclude in that circumstance that they are, or it's illogical to infer in that circumstance that that they're not speaking to you because they have nothing to say. So that's a bit of input on that situation. Good question. Last question.
And the last question I'm going to be able to take, based on time, is that Heather's asking about a recent incident and case that has just come out of Brock University today, or I think it was yesterday, in the sense of, can we talk about confidentiality of these processes? Many of our policies include a statement that the process will be confidentiality, but given the case that currently surfaced at Brock, is there something that we should be revisiting here?
Yeah, I actually haven't caught up on that case, and I ought not comment on any specific case anyway, but in general about confidentiality, I think, sorry, what was the last part of the question there, Lara?
Yep, so just many of our policies include a statement that the process is confidential, and just wondering if we should be revisiting that based on this incident that has just come to light at Brock.
Yeah, okay, so your policy shouldn't say that it's confidential because you can't promise absolute confidentiality. I think that's problematic legally. What they can and should say is, we'll keep it confidential to the extent we can, but we may need to disclose, what you tell us. This is to witnesses and complainants. We may need to disclose things to resolve the issue or basically to deal with the complaint. You have to have a qualified promise of confidentiality. If you're in Ontario, the statute has the new sexual violence statute has a provision in it that actually embodies a standard of confidentiality that is qualified. And it's only as confidential as, we're going to disclose this as necessary, and there's purposes in the statute that I don't have at the tip of my tongue now, but you can look it up in that statute, and that's essentially what you want to have in your policies.
Great. All right, in the essence of time, everybody, we have to wrap up, but I want to, first off, thank you all for joining us today and taking the opportunity out of our quite busy and hectic schedules for this important topic. And specifically, thank you so much, Dan. You're always able to share so many nuggets of knowledge with us, and we appreciate you weighing in and sharing your knowledge with us. So thank you so much, everybody, for joining us. And as I said, this information will be available on the caucus website for folks moving forward. And that